Hello friend, how are you? I'm Advocate Gaurav Kumar Gupta. I'm Chartered Accountant and MBA Finance and PhD holder. My project Derivative Market Future Trend Analysis. आज हम टॉपिक डिस्कस कर लॉ एविडेंस एंड प्रोसीजर के बारे में जिक्र कर रहे हैं सिविल प्रोसीजर कोड के बारे में जिक्र कर रहे हैं डिस्कस फुल्ली कंडीशन दैट आर रिक्वायर्ड टू constitute a matter of res judicata. Res judicata, Section 11. CPC defines the res judicata as under: no court shall try suit issue in which the matter directly and substantially in issue in a formal suit between the same party or between parties under whom they any of them claim between party under whom they any of them claim litigating under the same title in a court competent to try such subsequent suit. The suit in which such issue has been subsequently raised has been heard and finally decided by such court. Conditions: the following condition must be satisfied to constitute a matter as res judicata. Sodan Singh versus Daryo Kunwar, Supreme Court 1332. The matter directly and substantially in issue in the subsequent suit. Issue must be the same matter which was directly and substantially in issue, either actually explanation 3 or constructively explanation 4. In the former suit, explanation 1, explanation 6, 7 is to be read with this condition. The former suit must have been a suit between the same parties, between party under whom they any of them claim. Explanation 6 to be read with this condition. Such parties must have been litigating under the same title in the former suit. The court which decides the former suit must be a court competent to try the subsequent suit, the suit in which the such issue is subsequently raised. Explanation 2 and 8 are to be read with this condition. The matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court. Court in the former suit. Explanation 5 is to be read with the condition. Well, a matter directly is substantially in issue. The expression matter in issue means the right litigated between the parties, the fact on which the right is claimed, the law applicable to the determination of that issue. Such issue may be an issue of fact, issue of law, mixed issue of law, fact. It is the matter in issue and not the subject matter of the suit. The essential test of res judicata. Directory means directly at once, immediately, without intervention. It depends on the fact and circumstances of each case. A matter can be said to be substantially in issue if it is important for the decision of a case. Thus, the matter directly substantially in issue, former suit, will operate res judicata in a subsequent suit. Explanation 3, Section 11 makes it clear that a matter can't be said to have been directly or substantially in issue in a suit unless it was alleged by one party and denied, admitted either expressly or impliedly by the other. Thus, a matter in respect of which no relief is claimed cannot become directly and substantially in issue, even if decree is passed by a competent court between the same party. The second condition of res judicata is that the former suit must have been a suit between the same parties, between the parties under whom they any of the claim. A party is a person whose name appear on the record at the time of the decision. A party may be a plaintiff, a defendant. There may be res judicata between a plaintiff and defendant. Similarly, it may be res judicata between co-defendant and co-plaintiff. The test for res judicata between co-defendants has been let down in the case Mahbub Sahab versus Syed Ismail. AI 1995 Supreme Court 1205. It is concluded that if a party obtained a decree from the court by practicing fraud or collusion, has cannot be allowed to say that the matter is res judicata and can't be re- reopened. If there is a conflict of matter between plaintiff and it necessary to resolve the same by court in order to give relief to defendant and the matter is fact decided, it will operate a res judicata between co-plaintiff in the subsequent suit. A defendant to suit against whom no relief is claimed is called a perform defendant. Parties under whom they any of the claim comprise two classes of person. Parties actually present in the former suit, parties claiming under the parties to the suit, person represented by a party in the former suit. Explanation 6. Explanation 6 to section 11 deal with the representative suit, which means the suit filed by one or more person on behalf of themselves, other and other having same interest in the suit. Thus, the following condition must be satisfied before a decision may operate res judicata under explanation 6. There must a right claim by one or more person. Parties whose name are not mentioned in suit must be interested in such right. The litigation the litigation must be conducted bona fide on behalf of the interested parties. If the suit is under Order 1, Rule 8, all conditions laid down, then must have been strictly complied with. Litigating under the same title. The third condition of res judicata is that parties to the subsequent suit must have litigated under the same title in the former suit. The test of res judicata is the identity of title in the two litigation and not the identity of the subject matter involved in two cases. Competency of court to try the subsequent suit. The fourth condition of res judicata is that the court which decides the former suit must have must have been a court competent to try the subsequent suit. The expression competent to try means competent to try the subsequent suit if brought at the time the first suit was brought. Former suit denotes a suit which has been decided prior to the suit in questions whether not was instituted prior thereto explanation one. In order that decision in a former suit may operate a res judicata, the suit must have been either a court of exclusive jurisdictions, a court of limited jurisdictions, a court of concurrent jurisdictions. It is relevant to mention here that the competency relates both to pecuniary jurisdictions and subject matter. It has no reference to territorial jurisdictions. A finding of criminal court does not bind a civil court. In Banu Kumar Jain versus Archana Kumar and another 2005 सुप्रीम कोर्ट 626 while drawing a distinction between the principle of res judicata issue estoppel notice res judicata diverse a court from exercise its jurisdictions to determine the issue if it has attained finality between the parties, whereas the doctrine issue estoppel is invoked against the party. If such is an issue is decided against him, he would be stopped from arranging the same in the later proceeding. The doctrine of res judicata creates a different kind of estoppel by accord. The matter directly. and subsequently in issue in former suit will operate as res judicata in a subsequent suit. Here and finally decided by the court in the first suit, the last condition in that the matters directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the first suit. A matter will be said have been finally decided. Matter will be said be finally decided, notwithstanding that the former suit was disposed of ex parte or dismissed for failure to produce evidence when the time was allowed to do so. In Nohrala Verma versus District Cooperative Central Bank Limited, Jagdalpur 259 Supreme Court 664. The Supreme Court held that so far as res judicata is concerned, in our opinion, the appellant is right in submitting that the tribunal was not justified in holding that the application filed by the appellant was bare by res judicata. It is clear from the fact stated above that the application was filed by the appellant to joint register Raipur. It was pending meanwhile. However, District Bastar had in own registry and hence an application was submitted to District Registrar Bastar. The application preferred by the appellant to the joint registrar Raipur in the circumstances become the infructuous. It was not decided on merit. As per settled law, such decision does not operate as res judicata. The High Court was therefore right in coming to the conclusion that the tribunal was in error in dismissing the application on the ground of res judicata. That part of the order passed by the tribunal was therefore rightly not approved by the High Court. In Chandra Bhai Kumar Goyer versus Krishna Arjun Goyer, AR 2009 Supreme Court, 1645 order passed without jurisdiction is nullity. It will be quorum non-judiciae is it is not east is the eye of law. The principle of res judicata will not apply to such case. In Harvansh Singh versus Sanat Hari Singh, AR 19 Supreme Court, a suit filed by person in charge of affairs of Gurudwara that he was Mohatmim of Gurudwara and for permanent injunction, and another suit filed by managing committee of Gurudwara for declaration that plaintiff is connected suit was not motimim. Dispute between parties to both suits were common and issue raised therein also common decree for permanent injunction granted in favor of plaintiff in first suit whereby managing committee was restrained from interfering with his position. The decree attaining finality second appeal by vice president of managing committee not claiming any interest in his individual capacity, whereby res judicata, bared by res judicata in Sarva Shramik Sangh versus Indian Oil Corporation Limited. Year 2009 Supreme Court 2355 it was held when the case of the workers is that the contract was same and nominal. They could seek a relief that they should be declared as the direct employees of the principal employer if the contention filed and is found that the contract was valid. Then they can seek issue a directions to the central government to consider their representation for abolition of contract labor, similarly, where the workers contend that the contract between principal employer and the contractor was same and merely a camouflage to deny them the benefit of labor law if their prayers for relief under CLRA Act is rejected. They can the seek relief under the ID Act, the contention of IOC that on account of the dismissal of the first petition. The second petition for a different relief was barred either by principle of res judicata, principle of estoppel, would be liable to be rejected. When the parties are different issue are different relief are different the questions of either res judicata, finality of proceeding, acquiescence, estoppel will not arise. In Haryana State Electricity Board MS Human Rice Mill and ORS 2010 for PWR Supreme Court 61 first suit filed for the permanent injunction to restrain appellant from enforcing demand notice in respect of charge incurred by previous owner. Second suit sought a declaration that the consequential disconnection of electricity supply for area of previous owner was invalid. For consequently relief matter was not the same in both suit and relief claim were also different. Second suit was not whereby res judicata. Explain the concept of constructive res judicata with the help of registration. अगले वीडियो में हम आपको एक्सप्लेन करेंगे कंस्ट्रक्टिव रेस्ट जुडिकेटा होता क्या है। आज का वीडियो यहीं वाइप आउट करते हैं।